I was.
You're Nathaniel Clark?
Yes. I was a court appointed attorney, and I was just informed that he has retained counsel, so I'm going to step back and turn it over to.
And you or Mr. Manning?
Yes, sure.
Okay. So let's see. You're charged with, you're Nathaniel Clark.
Yes, sir.
Do you understand you've been indicted, and this was 7 months ago, for the third degree felony of operating a motor vehicle in a public place while intoxicated? You have, though, that's not the worst part of it. You've got prior convictions.
Got it.
Don't interrupt me. When I'm through, you have a fair opportunity. Okay. There's, according to the grand jury, in 1997, you were convicted of illegal possession of marijuana out of Wichita Parish, Louisiana. My family's right. Then the third paragraph goes on to allege that after that felony of illegal possession of marijuana was finalized, you committed the offense of aggravated battery and were convicted in Wichita Parish, the same fourth judicial district court of that offense of aggravated battery in 99. So
quick pause. Tim, thank you for gifting my 5 memberships. Appreciate that very much, sir. Thank you.
if you are convicted of this third degree felony of operating a motor vehicle in a public place, and if these 2 other priors are indeed valid, then you're looking at no less than 25 years imprisonment to life in prison. Do you understand what you're facing according to this indictment? Yes or no?
Yes.
Okay, well, as long as you know that. And also, you're not eligible for probation for this office. So what are we going to do? Mr. Manning?
I'm sorry, go ahead.
Oh, yeah.
I'm just aware of the situation.
Yeah, well, that's what happens when I was defense attorney a long time.
So
Those things fall in your lap, but I don't wait around. I move forward, especially when it was indicted last year.
Right. So I believe that we're working with under discovery.
What is that? Okay, it's 7 years. What happened to the guy before? He was representing him.
John West.
Well, John, you had him for 7 months. Did you pass all the information to Mr.?
No, I had him for 7 months. He's been following. I wasn't appointed that. I'm not sure when I got appointed. I was appointed recently. I've only had 1 court date here.
And at that court date, Mr. Clark did not appear. He had a failure to appear, and you increased his bond to
You were the
$100,000.
attorney in January, as of January. And there was an initial docket. It was reset until February, and then that was reset until March.
Yeah.
Then that was reset until May, and then that was reset until later in May, and then that one was reset to, I think, today. Yeah. So what is that, 5 resetting? Bad gum. Come on.
Yes.
All right,
I don't know if off the top of my head, Your Honor, and I can't. Have you related things to your prior counsel as far as the office? Yeah. We did. We didn't get a chance to get to that. So it's 4 versus 4.
what are y'all gonna do? What are you gonna do?
Well, I have concerns with Mr. Clark because he failed to appear. You increased his bond to $100,000. He posts the bond the next day. He gets out and he's alleged to have committed a new assault, family violence.
I'm not aware of that.
I filed a motion to increase his bond, and that is actually what this is set for this morning.
Okay, okay, I'm looking at it.
Yes, sir.
And what happens, you tip me off ahead of time.
I apologize.
That's okay. This was filed on the 9th, but when it goes into the file, I don't see it until I break open the file of the docket. This states he's accused of family, an injury to a family member in 26 CR 1567. Can you pull that for me?
Gotcha. You're up 87665. So, sorry, what did you need, sir?
26 CR 1567.
If you're interested about the PC, Judge, I have that from the,
I just want to know, I want to look at when that got filed and
it was filed on June 5th. The offense occurred on June 3rd.
I can go.
why did we increase his bond?
We increased his bond because he didn't appear in court properly on May 27th.
Did you have?
And the next day he goes down to, actually he goes down to the jail that day and posts the $100,000 bond. And then within 5 days, he's alleged to have committed a new offense.
Did you have any practice in courtroom?
Why would I know that, sir?
No, so they did our counsel like anybody had to.
Again, why would I know that?
Right.
I thought you were clairvoyant.
I've been told a lot of things. That's
But
not
not
what I
Claire.
am. No, sir.
First name, it's not been known as Claire.
No, sir.
Well, that's what he just related to hear. There's issues here. Moving with another court.
I don't care. What I care is that he was out on bond and commits a new offense.
Yeah, well, no, I'm saying as far as it looked accessible, the failure to appeal.
Sometimes it's
Sorry, Judge.
Sometimes it's amusing.
He
just
keeps,
listening
he keeps
to-
visiting with me instead of
He's
Your Honor.
learning. He's trying
Yes,
to
sir.
figure it out.
Yes, sir.
I was defense attorney for a long time and things always surprised me with, I was the last to know a lot of information about my client.
Well, now, as far as that goes, Judge, he has taken the original step to go through the portal to get discovery. I've seen the initial email and the response from the district clerks, but that has not been cleared. He's going to have to get with the clerk's office because he's new to the system. And so he has not had access to the
Okay, so now,
correct.
Okay.
we don't have their files, nor can I have access to get to theirs. If Mr. Ham has the PC, that might be the only way. we can get
You
it.
have the information.
At the PC here,
You know,
and I can
the information.
I can print you out that, Judge.
Thank you.
Yes, sir. Give me one moment, Judge.
Still very. Sean Villar's Hamilton. Thought my boss and your boss talking about this and I go, but don't move, so I'm just gonna go do the thing and look down later. Yeah. Didn't trickle down. So he said it all, but I don't know anything about it. Supposed to play it.
We have a copy of this.
I hadn't seen it.
Okay, we'll make a copy.
It's gone. It's go to August. Okay, cool. Did you see, is the original, was the original for only 10? Yeah, it's not, is that correct? Sorry.
Yes.
Curious, was it any notices and chance why it go from 10 to?
Didn't appear in court.
Typically, dealing with Shelby. Is that in a typical case?
That was his decision, not mine.
It's always my decision.
Oh,
There's no litmus test except for the circumstances of the situation. The thing was, I felt that was,
Somebody grab that item.
Sure.
when did he, when was the bond? Increase?
May 27th. 2026.
Yeah, it was because, it was, a date for a plea. According to the attorney, and he failed to appear. Thank you. Oh, it's not for him. Thank you. It's wonderful. That's why that bounced up.
That's why it's requiring this to be.
There's always a reason. It's just a matter of figuring out. Generally, I double it. But if there are other circumstances, I rely on representation, the attorney and the defendant, and then if they don't, they can always change their mind, but they need to be present.
Yeah, obviously not.
You want anything else from that misdemeanor file? Judge? Do you want anything else from the misdemeanor file?
It's leading an intended case.
All right. Okay, Mr. Manning, what are you gonna do with that? From the defense side.
As far as today, I actually was making a request, he's on the tax, why, because if he can come back to Monroe and move back with his family.
Sir?
If he can come back to Monroe and actually have his home confined to Monroe.
What am I, why?
You entered a condition on his bond of home confinement after his failure to appear on May
Whatever,
27th.
well, he's on home confinement, whatever his home is.
His home is here. His home is here, Judge.
Yeah, so if it's
why-
here, but I mean, if he
So
moves to another home, that's okay with me.
Okay.
But it would be home confinement. But here's the problem is that I've got this motion now for an increase in bond. And I've got the information that's been filed that alleges a misdemeanor of assault on a family member, which is never. It's serious because if you're going to assault a family member, what are you going to do to someone that you don't know? And hold on, and this occurred on or about June 3rd is what this alleges. And this was filed on June 3rd. And what had happened was, unbeknownst to me, a week later, the defendant was here on June 10th. Right?
Not to my knowledge.
2 weeks ago?
Not to my knowledge.
Well, who's that? No, since I've got 5,000 cases, I have to see on that date, it was set for that. And that was reset.
That's a notice based upon the motion I filed. It wasn't his appearance, Judge.
This case is reset on the hearing. Yeah, okay. On 6/10, when this case is reset for a hearing on 6/24.
They reset, they actually
He
set.
was here on 5/29.
He was not here on 5/27. He gets out on the new bond, alleged to have committed a new offense. I filed a motion to increase his bail on June 9th. The court on June 10th set it for a hearing today on that motion to increase. The logistics are, he now has a new lawyer who hasn't had any access to the discovery.
Well, we still, notwithstanding that,
Yes,
we're
sir.
going to take up the matter of a bond.
Yes, sir.
All right, what are we going to do today, gentlemen, on the motion to increase the bond?
in our position, the $100,000 bond, that was significant bond in this situation. You're reading about woman's wife, or they're going through a divorce. And these are just these allegations that she made, suggesting that she was injured with a wrist injury. I hadn't seen the medical records to support that, not saying that, anything didn't occur, but she's claiming that significant or some injury occurred. I believe that the $100,000 bond is, and also he's in the position we want to live at home, yeah, that he's now filing for divorce to get away from her. So I don't know if that going to be an issue. I know situations with her in the last 10, she's in a situation where she was basically trying to hurt him, with him not want to be with her.
What's they say?
Oh, no, like it.
This has been looked at by our office. I've actually talked to this complaining witness. The probable cause sets out the facts there. We've determined that there's more than sufficient evidence to move forward with the accusation. And the problem that we've got here is a man who has a criminal history, who's out on bond, who just recently got out on an increased bond, is alleged to have committed a new offense, and it shows a danger to the community, not only to Ms. Clark, but to anybody else. The theory that there may have been some divorce filed is insignificant compared to what the accusation. The bond needs to be addressed. $100,000 is not sufficient. It needs to be increased at a minimum.
Oh, Mr. Manning, what do you ask? We kind of knew that all of it, but sometimes you get thrown into the game when you're warming up.
I mean, I believe that even with the $100,000 bond within this in court, I believe it's custody under central discretion.
Yeah.
So, but I mean, we went from 10, I believe it was originally 7, and it went to 10.
There's no, yeah.
And then it went to 100. So,
Notice how both sides are arguing completely different questions. The defense is reminding the court that these are still allegations, while the prosecution is emphasizing the pattern of behavior. That's a crucial distinction. Bond hearings aren't mini-trials. They're about whether the defendant can safely remain free while the case moves forward. And based on everything we've heard so far, the judge appears to have already reached a pretty strong conclusion.
Because that was the third time we had to increase it, right?
well, I think
Judge, not to interrupt Mr. Manning, but I believe the whole reason why you increased it is you felt like 10 was insufficient based upon his criminal record. And then with him not showing, it just made matters worse. And that's why you entered the amount, Judge.
What bothers me too is he's got an aggravated battery conviction. Assault, it's assault of nature. And here we are on my watch when I have allowed him out on bond. He's accused. There's a charging instrument now filed with probable cause that states that you committed another assault. You know, this dangerousness to the community is enough and probable cause to believe that you've committed a crime is good enough for me to raise your bond again. But and let's don't forget, you're a habitual offender. You got no room for mistakes, especially assaulting, being accused of assaulting a girl. When I grew up, that was laughable. You don't assault girls, a man. Your bond is increased to $200,000. You understand? And the same conditions will apply. If you get out, you're at home, but you have no contact with any victim of a crime, including this. And you have to have a GPS device, and you can't leave the house except for food, to see your lawyer, for medical needs in the most direct route possible. Anything else? You raised your hand. What do you want to say?
You know, get accused, not the truth, I guess accused.
Probable cause is enough for me to raise your bond, sir. You've the probable cause to believe you've committed another crime. And here's probable cause affidavit. Your attorney has a copy of it.
he is covered.
Thank you, Judge. He
And
may actually already have he should already actually have the GPS from the car.
Yes.
and before he leaves, before he's taken in, before he's taken to jail, I'm going to test him to see if he's on any kind of controlled substance. What are you going to do next, sir?
So we need to reschedule.
Yeah, you don't want to, you want to, is 2 weeks good? Something be done in 2 weeks, you think?
You know, with the issue. Send me an email. I don't know if.
3 out of Louisiana?
You say you found this from.
Well, I mean, yeah, Louisiana people have a problem.
Yeah, that's right.
Fix it.
I think he's gonna go back
Okay.
to the district
Yeah,
clerk.
so
Okay, it's fixable.
Yeah.
Just if you have a problem, talk to the staff. They can help you go through it.
All right.
Yeah.